All right, and we are recording. So welcome committee members, liaisons, and members of the public to the Legal Services Trust Fund Commission Homelessness Prevention Funds Committee meeting. Thank you for joining us. We're going to begin probably here in a couple of minutes. And I'll start by making a few housekeeping announcements. We are using Zoom with the goal to foster a more inclusive environment and effective meeting. If you would like to comment during the meeting, please type into the chat, I have a comment or I have a question, and a message will be sent to the host. Alternatively, you can use the raise hand feature in Zoom, which is at the bottom of the screen and has the icon of a hand. In efforts of transparency for all those joining this public meeting, whether by phone or by Zoom, we request that you refrain from having side conversations on chat about the content of the meeting. Again, the chat feature is utilized simply as a tool for you virtually to indicate that you would like to speak in order to help the chair facilitate the discussion. All Legal Services Trust Fund Committee and Commission and committee meetings are recorded and posted on the State Bar's website, including this one. And a friendly reminder that this is a video conference, so please be aware of your surroundings behind you. All right, and that concludes the housekeeping items. So Christian, if you like, I can start with the roll, or we can wait a moment.
No, let's get going and start with roll, if you would, please. Thanks, Chris.
All right, thank you. So taking roll, Schreiber
Here
is present. We know that Aklagi is absent, unable to attend today. She's a trial. Alsaroff is, oh, I have a note here, is going to be arriving about 15 minutes late. We know that DeBose, Herman DeBose, is out of state and unable to attend. Iskin?
Here.
Meeker?
Here.
Renus?
Here.
And Savage?
Here.
All right. And we do have a quorum. And Alsaroff will be joining a few minutes late. And then, Christian, I think our first agenda items are discussion and approval of the meeting minutes from December 3rd, 2020 and December 15th.
We want to indicate who from the public is here.
Oh, great. Yeah, thank you. Yeah, so liaison, so apologies. For our committee liaisons, Copeland, Selena Copeland from LAC.
Present.
Bonnie Huff from the Judicial Council. I see Bonnie has joined but is on mute. And then Christine Ganong from the Board of Trustees. You can see Christine. And Mark Toney also from the Board of Trustees. Okay, I don't see Mark. And then for State Bar staff, Dwan Nguyen.
Here.
Chris McConkey is here. Danielle McRae.
Here.
And Brady Dewar. And I think I see Brady as well. It's just on mute. Okay, thank you for that reminder. Yeah, so we have a quorum, and then just a note to the chair that our first two agenda items are approval of the meeting minutes.
Oh, sorry, Chris, would you like to do the public comments before you do the approval of the?
Yeah, I will just invite any member of the public that would like to speak at this point to step forward if there is any public comment.
I know I normally talk during the liaison portion during the content, but I just had like an announcement at the beginning. I wanted to invite members of this committee to join a presentation. Jim Meeker and I are co-chairs of the Access Commission's Rural Access Committee, which I think is relevant to the homelessness prevention rubric creation later. We're opening, actually our subcommittee meeting opening up to other members who may be interested to learn about unincorporated areas of California. So if anyone's interested in that, I'm going to send one the Zoom invitation Jim, I think we're doing it next week, but we're having a presentation on unincorporated areas by an attorney from CRLA.
And I can send it to the full commission if you
Oh,
think that's
okay.
appropriate. Okay.
I'll send you the Zoom. I think we just are setting it up today. I believe, Jim, is a meeting next week or the week after?
No, next week, Monday.
Oh,
The days march on, Selena. Thank you for that. Is there anybody else that would like to make an announcement? All right, I would just like to welcome our newest staff member, Danielle, and tell her we're looking forward to working with you on this. And it's a lot of good work to be done. So welcome aboard. Okay, with no other further public comments, let's go ahead and approve the minutes. Can I get a motion to do that?
I move to approve the minutes.
Thank you, Jim. Is there a second?
Second.
Okay.
May I ask, Christian, if this is a motion to approve both of the minutes together or just December 3rd?
Oh, I intended it to be both sets of minutes.
All right.
Yeah. Jim
Thank
and yeah. Okay. Okay, further discussion? Let's take a roll call vote.
All right. Schreiber,
Yes.
Al-Suraff is not here yet. Iskin,
Yes.
Meeker,
Yes.
Arenas,
Yes.
and Savage.
Yes.
Motion carries. All right. And thank you, Christian. The next item on the agenda is discuss and approve recommended timeline for the new homelessness prevention formula and competitive grants.
Great. Thanks, Chris. I'm going to hand this off to staff to go through. Obviously, if there are questions about this timeline, please go ahead and raise them. But I've spoken to staff and have previewed the timeline, and we will obviously have an opportunity to discuss it. But I think this hopefully will not be controversial. But go ahead and take it away, Chris. You can share your screen or however you're planning to do that.
Perfect. Thank you. Yeah. So staff has a presentation for the committee. So good morning, everyone. So the staff's presentation will lay a foundation for a discussion of staff's proposed timelines for two funding sources. The new homelessness prevention, it's the Assembly Bill 164 homelessness prevention formula grant, and then a separate timeline for the homelessness prevention competitive or RFP grant. So we'll just discuss briefly Assembly Bill 164, the activities that it is meant to fund, some features of the formula grants, some distinguishing features of the RFP grants, and some related provisions. And then we'll present the timelines, and then we'll end with some proposed resolutions for the committee to consider. And I encourage everyone to, committee members and liaisons alike, to jump in whenever they have a question. There's no need to hold questions for the end. It might actually be more helpful to sort of make sure everyone understands each of the statute's provisions as we go along, since the presentation builds on itself. So the governor signed Assembly Bill 164, which amends the Budget Act of 2021, and he signed it in mid to late July. It allocates $40 million to the Judicial Council to distribute through the Legal Services Trust Fund Commission as grants to qualified legal services projects, or QLSPs, and support centers. The grants are to provide, and this is mostly copy and pasted language, so staff didn't paraphrase this, eviction defense, and there's an expansive list of examples that is very similar to the examples that were in the last batch of homelessness prevention fund grants. Other tenant defense assistance and landlord-tenant rental disputes, or services to prevent foreclosure for homeowners. And that third bullet point is new language that wasn't part of the authorizing legislation for the last homelessness prevention grants, but new to this one. Again, just an overview. It provides up to 2.5%, which is $1 million for administrative costs on order of the Department of Finance. And then 75% of post-administrative costs will go through the a formula process. So that's up to $29,250,000, and 25%, or up to $9,750,000, will fund competitive awards. So this is just an overview slide, and I'll go into a little bit more detail about the permissible activities and the formula and RFP process.
Chris, Jim has his hand raised. Can you stay on that slide? I also have a couple of things to add, but
Absolutely.
we can take Jim's question first.
Yeah, my question is on the 1 million for administrative cost. Is that go to fund the staff for Legal Services Trust Fund Commission? I mean, how is that spent?
It's $1 million, and we share it with the Judicial Council. So Bonnie and I are smoothing out kind of the terms of the Judicial Council and the State Bar contract right now. And historically, we've shared that administrative cost, 2/3 State Bar and 1/3 Judicial Council. And if we don't spend the administrative costs, then it gets distributed as to programs. The last kind of tranche of HP funding, there was some funding that was provided to LAC to provide some technical assistance, some training, some support, so that can get rolled into administrative costs too. But yeah, it's mainly staff costs.
And that's sufficient to cover it?
Yeah, it's sufficient.
If
It's
in
we'll probably have the
combination, I'll say in combination with the funding, the administrative funding for the Equal Access Fund. This is because of well, this is going to be a little bit more challenging to administer, but we can make it work.
Yeah, and you know, Bonnie and I have talked kind of a high level, maybe carving out some of this money, perhaps to outsource a little bit to a private evaluator to do some more like high level analysis, and that'll come out of the admin. But yeah, it's mainly a Judicial Council and State Bar staff that's being funded by that, and we don't anticipate that we'll spend the whole $1 million. And I think Rich had his hand, and then Kim had her hand. Okay.
Jim really led me into this. I think approval of this thing with that sort of budget should have amended to it, or at least what we should be looking at as a commission is how to conserve as much of those administrative costs as possible, because they may be duplicative of other costs that are covered from IOLTA funds or wherever else. And you know, sort of set goals or some sort of incentives for staff to try and save some of that so we can distribute more money to the QLSPs.
We're really leanly rich. I mean, we can definitely do that. But if you compare our administrative costs to any other, not just private foundation, but similarly situated government funder, we're really, really on the lean side.
No, I agree with you, because I actually did that about 8 years ago compared to private foundation. We are extremely lean for a very large foundation, if that's the way you look at it. And that's a fair way to look at it. But it would be nice to build in incentives so that we can do that and demonstrate to the legislature that we can work within those budgets, and that we're to be trusted with the funds, and that we dealt with it appropriately. And
I think part of our efficiency is why the legislature keeps providing us money, because we have a system that's in place, we're plugging into an existing infrastructure that works. Kim,
mine was actually a question for Bonnie, following up. Bonnie, I thought I heard you say that these funds were going to be more difficult to administer, and I just wanted to understand what you meant by that statement.
Well, I think Chris and Juan are going to be able to, we're going to have to do quarterly reports to the federal government on how the funds are used and main benefits and a lot of other things. And we've never had to do that kind of level of reporting before. And I suspect that because these are federal funds, there may be other things that we're all just learning about in terms of what's going to be required. But that's what we know so far. We already had a report that we had 8 days to turn around that I think that may be a harbinger of things to come.
Yeah.
Oh, there goes those administrative costs. Okay, thank you.
Yeah, there's a slide later on, Kim, where we go over the reporting requirements, but
Okay.
because the funding, the stream for this is the coronavirus federal rescue plan. There's a lot of things that the Judicial Council and the State Bar staff have had to kind of try to figure out in terms of not just reporting requirements, but with federal funding, there's triggers for additional audits and requirements and bidding and all that good stuff. And there was a webinar that we all attended from the Department of Finance a few weeks ago, but it's very, very technical. So we're trying to digest it so that we can distill it to programs, because they're going to be more requirements.
Okay. And of course, the programs, the recipients will need to understand that also, I guess.
Once we understand it, we will distill it, but we're trying to wrap our heads around.
Okay, thank you. Very helpful, thanks.
And I believe Eric and then Selena.
Yeah, I mean, is there a plan to hire more staff?
Excuse me, Eric?
Is there a plan to hire more staff? There
is a plan to hire more staff. There's also, we have some postings right now. The job market is just really difficult right now to hire. I would say, I don't know if employers are in the driving seat. We've had a posting for, we're fortunate we have Danielle that came on board a couple weeks ago and has been really excellent. And we've been trying to hire the other senior program analyst for the last few months. High volume of applications, not so much great fit. But I had 7 screening interviews last week. I'm going to advance one of them to a second round. So that person we might make an offer. We'll see. We also have, so we are in the process. It's just not easy.
And
Selena.
just on the administrative burden piece, I suspect that this first year will be a lot of administrative work for Judicial Council and State Bar, specifically for the point that Kim raised, is that programs are going to have a little bit of a tough time reporting something that is so new to them. With this quarterly reporting, I think there's going to be a lot of technical assistance in the first couple of quarters. LAC have been advocating for up to 5% instead of up to 2.5%. And I wish it had been up to 5% to have the flexibility to have in year one more technical assistance, because I think that's going to be where the biggest burden is in the first year. And in future years, it won't be as bad, but because this will be multi-year grants, you'll have the same programs doing it. But year one, I'm already kind of answering questions about the single audit, because organizations are raising, do we have to do a single audit now? And Dwan says the answer is yes. So if they meet that threshold, so this is a new thing for programs too.
Oh, it's just a couple of quick notes, and I know we're gonna I'll just be brief. So this AB 164 is the third iteration of the Budget Act, and there was substantive cleanup that had to be happened for this particular part of the HP grants. So it's in a form that we're pleased with. There was some bad cut and paste jobs, but they removed it. And I don't know if you all remember, but there's also pending AB 1487 for homelessness prevention funds, but it looks substantially different than this. This is the legislation that Kim Savage on the commission and I kind of gave feedback and with the LAC too. That's still kind of moving its way, and we don't know if it's going to get passed, but if it does, it doesn't seem like it might be funded this year. So I'll keep you apprised if there are more updates, but just know that's still live and it's not dead. It's just we're focusing on this because we know this, we need to distribute this quickly. Okay, Chris, I'll pass it back to you.
So this slide just captures the permissible uses for both the formula and the RFP grants. We erred on the side of copying and pasting the language, since we realized that even paraphrasing it could slightly change the meaning of the sentences. So both grants are to fund eviction defense, other tenant defense assistance, and landlord-tenant rental disputes. And then we've highlighted in yellow language that is new this year. So, or services to prevent foreclosure for homeowners. And then the statute goes on to say that includes pre-eviction and eviction legal services. Again, this was also in the previous authorizing language for the last tranche. Pre-eviction, eviction legal services, counseling, advice and consultation, mediation, training, renter education and representation, legal services to improve habitability, increasing affordable housing, ensuring receipt of eligible income or benefits to improve housing stability, new language this year is legal help for persons displaced because of domestic violence, and then homelessness prevention. Any questions on this slide? Okay. So then the statute goes on to specify how the formula funds should go out. So again, up to 75% of the amount of funding after administrative costs, or up to $29,250,000. To qualify, QLSPs and support centers must have been found eligible for 2021 IOLTA funding. That's an expediency strategy, just to make sure that the grants can go out as soon as possible. The legislature is letting the commission use a previous eligibility determination for these grants. There does need to be a determination, though, that the QLSP or support center currently provides eviction defense or other tenant defense assistance in landlord-tenant rental disputes, quote, as set forth in this provision. The allocations must equal the eligible applicant's share of the total formula grant funding. Each eligible applicant's share of the total formula grant funding will be proportional to its share of total 2021 funding for IOLTA. But just looking at those organizations that qualify for the formula grant. So it'll be the same percentage of the total amount of funding available. However, each formula grant will be at least $50,000 unless the applicant seeks less. Similar requirement to the last iteration, that the funds not be used to supplant existing funds. And then the legislation says that the commission needs to distribute the grants as soon as practicable. And I saw at least one hand go up. So Eric.
Yeah, so given the broadened definition of services that qualify as homeless services, as indicated on the previous slide, looks like more and more organizations are going to be eligible for this. So for example, if you didn't do any eviction defense, but you did domestic violence restraining orders or something like that, would you now be eligible to receive a formula grant? I mean, in other words, is it sufficient that any portion of your services involve homelessness services, even if it's 1% or 5%?
You know, with that one, the DV clause, you know, I personally don't think that was necessary. That was advocacy by a particular program. There's still going to need to be a nexus between help assisting somebody, a survivor of DV, with helping to prevent their homelessness. And we've allowed programs, if you recall, in the last two iterations of HP to pitch that and give us an argument. And there were programs that did it successfully. There was one program that didn't, and so advocated for this change. I don't think that one will broaden it so much. That program will now make it a little easier. The one that will open, Eric, you're right, is the foreclosure piece. That programs will now be able to. I think that's the biggest substantive change, is programs can provide now foreclosure assistance work.
I suppose.
So to qualify for this, so thanks for that clarification, but to qualify for this, is an organization only required to devote some of its resources to homelessness work, even if it's only 5% or 10%? In other words, if you do any homelessness prevention, any eviction defense, even if it's only a small portion of your overall work, you can qualify for one of these grants, formula grants?
There's not a minimum threshold on how much they have to do. They just currently have to be partaking those activities. But obviously, with the budget, they have to budget for all qualifying activities.
Kim.
My comment is, this question is kind of similar to Eric's, but a different example. I mean, I get the legal services because it's for people who have been displaced because of domestic violence. So there's the linkage to eviction. But I'm looking at increasing affordable housing. There are affordable housing developers who I think are IOLTA recipients that do a lot of that. I may be wrong, but this could mean, this is a question, could they just be developing or increasing affordable housing, but not have a connection to eviction defense work? I mean, I'm thrilled that's in here, but it doesn't really fit.
And there's also, and that was in there before, and then as was like ensuring receipt of eligible income or benefits, which is, and for me, it's kind of getting at that catch-all in the very last bullet point where they're both homelessness prevention measures. It is interesting that the sort of global phrase at the very top, eviction defense and other defense assistance, a really narrow reading of that, I guess might make you otherwise think that those things wouldn't be included, except that the legislature then itemizes all the things that they think contributes to homelessness prevention.
I would have phrased it a little bit differently, eviction defense and housing opportunity or something like that. But anyway, I'm not in the legislature.
Because then the list is like, okay, then it makes sense. Yeah.
And I'm happy to give a little bit of background on that, because as you can tell from this language, it's really copy and paste from HP1 and HP2. With an add-on at the end for the legal help for persons displaced because of domestic violence. And the reason why we had a little bit of like a menu of items is there was concern from the legislature that it would only be used for eviction defense. And to paraphrase Gary Smith, who paraphrases the guy in New York, the rent is too damn high is the problem. And so income maintenance is really key to preventing evictions, because you want to make sure if people have access to income to increase their household income, they're actually at less risk of eviction if they're unable to pay their rent. And then the affordable housing was a piece for a lot of organizations, really do a lot of policy work with local agencies to increase affordable housing, which to them that prevents future evictions because people can actually afford eviction. So the kind of laundry list or menu was intended to make sure that it didn't get too narrowed to just eviction defense, because once you have a UD, it may be too late to solve the problem. And Dawn is 100% correct that the legal help for persons displaced because of domestic violence was concerned from a program that they wouldn't fit under homelessness prevention. I think that work clearly fits, honestly, under the big category of homelessness prevention. It's not just TROs, it's really things like helping people who've been displaced because of domestic violence, help them get into new housing units, help them with income issues so that they are able to get in new units. Maybe some advocacy because maybe they've had prior calls to the police from their past units, and so they can't actually get new housing because they have too many marks on their record. So there's a lot of different things that could help people get into a new safe housing situation. But yes, it is funny that there's this kind of like blanket statement at the top and then a laundry list, but then the big caveat at the bottom of everything that's homelessness prevention should qualify under this.
Well, for the programs, the broader, the better. And just hopefully whoever is reviewing the use of these funds will understand all the connections. So it's great for the programs.
Okay. And I presented on the slide just a moment ago, but I should point out the bullet point 2 here, to qualify KOSPs and support centers must, and then the second sub bullet point, currently provide eviction defense or other tenant defense assistance in landlord tenant rental disputes for the formula grants. We interpret, and I encourage Dwan and Bonnie and Brady to weigh in too if this sounds not quite right to them, but we've interpreted as set forth in this provision as referring to and capturing the full list of activities that the legislature says these grants are meant to fund. Even though the language right before it sort of makes it again sound like it's eviction defense, but for the reasons that Selena just described, they do itemize a much more inclusive list of homelessness prevention activities.
We thought that was the most logical reading, is to take the more expansive versus the more narrow, because this would be really narrow. But we do invite the committee's opinion and Selena and Brady and Bonnie on that, how we read that.
The alternative would be the reading of this qualification provision with like the narrow reading that Steph doesn't recommend is it would be that these grants can be used for the expansive list, but only those programs that currently provide eviction defense or tenant defense assistance could qualify for those grants. But then they could then go on and use it for domestic violence prevention or foreclosure prevention, which we think is inconsistent with what the legislature was meaning to do with the funds. Brady, just the person I was hoping would weigh in.
Sure, and we discussed this a little bit over email last night. I think that, and this was a sloppy, no other word for it, but so talking about what sort of services they must currently be providing. It says currently provide eviction defense or other tenant defense assistance in landlord-tenant rental disputes as set forth in this provision. I think you're absolutely correct. As set forth in this provision has to mean something, and it means it's importing that long list of examples as to what's included. However, and I think that, you know, hopefully this wouldn't make a difference for any applicant, but what they've done is they've said you must provide pre-eviction an eviction legal excuse me, you've changed the slide. Can you go back?
Yes. There you go.
Eviction defense or other tenant defense assistance in landlord rental disputes. So they've taken two of the three main categories of things that you can spend the money for. Because remember, now you can spend the money on eviction defense or other tenant defense assistance in landlord rental disputes. But they've also said this year you can spend it on preventing foreclosure. Well, now in talking in this provision, in talking about you know, the three things that you or the things that you must currently do, they leave out that addition of homelessness foreclosure, but they, you know, include with this as set forth in this provision all the examples of tenant defense assistance and eviction defense. So, you know, I think if you were to strictly adhere to the plain meaning of this language, it's that you must currently engage in eviction defense or other tenant defense assistance, which means counseling, income maintenance, homelessness prevention, yada yada yada. But it doesn't include that new addition of foreclosure prevention. Hopefully, this is academic. I doubt that there's any. Or you tell me, but I would be surprised if there's any organization that is doing currently foreclosure prevention and is not doing a single one of those other things like income maintenance or domestic violence or counseling. Homelessness prevention is even one of them. So hopefully it's an academic point.
Brady and Jim.
Yeah, well, just to expand on the academic point, are we going to make this broader interpretation clear in the request for proposals?
We would make it clear in the application instructions and in staff's webinar to programs, assuming the committee and commission agree with it. Okay. All right, and thank you, Brady. That was helpful for me. Okay, so for the RFP grants, again, it's the formula grants and the RFP grants each get their own subparagraph that live in the statute or the bill under that global list of activities. So this one is 25% of the fund, which is up to $9,750,000 will be available for RFP grants. Quote, to provide eviction defense, other tenant defense assistance in landlord-tenant rental disputes, or services to prevent foreclosures for homeowners as set forth in this provision to meet the needs of tenants not addressed by the formula provided in subdivision A. These grants also are not supposed to supplant existing funds for the programs, including any allocation they might have received under the formula provision. This paragraph specifies that the commission must make award determinations. I added that here just because the formula grant paragraph didn't include that, but it is in this one, and it must give, the RFP process must give preference, and this bill uses the word shall give preference for legal service organizations that, quote, serve rural or underserved communities. And then the last bullet is sort of a logistic measure. Any funding that's left over from the RFP process will get distributed by the same formula as the formula grants, but without the $50,000 funding floor.
And as you recall, the sticking point the last time we reviewed HP grants was that language between serve rural or underserved communities. So when we go to do the rubric, we're going to really have to flesh out and provide a lot of clarity for programs on that piece.
How are you going to? It sounds like we have the same ambiguity with this language that we did.
Well, we grouped it last time. Our suggestion, once we get there and develop the rubric, would be to separate the or out. But we can talk about that once we flesh that out more. And I think, Jim, did you have your hand?
Yeah. Well, one was the rural or underserved, because that was an issue last time. The the other thing was the last round, Chris and I were kind of taking the attitude on the discretionary grants of favoring those who are doing something different, as opposed to merely doing more of what they were doing under the formula grant. And I was wondering, are we going to put any language like that in there, or we decided not to do that this time around, or what?
Well, we need to, as a committee, decide how you want to deal with it and make the pitch to the commission on how what are like what the scoring group would look like and what the priority areas are.
And are we going to put an upper limit?
That's all to be discussed. This is just, today is just the timeline.
Yeah, and as you'll see on the timeline in a couple of slides, either the commission or the committee, and we recommend that it be the HP Funds Committee, will have to meet again at the end of August to approve a scoring rubric and RFP. And so the way that process will likely unfold is staff will take all the lessons learned from the last round of HP RFP funding and make a proposal on things like that. And then the committee will have a chance to say, I like this, I don't like that, let's change this. And so there'll probably be a late August meeting where that can happen. But actually, if you have thoughts now, I'll take them down. And then the first draft of my scoring rubric and RFP will reflect your input. So this is a good forum for sharing those thoughts. Before I move on, Brady, was there anything, just because this is like the corollary grant, was there anything you wanted to say about this one in the way of statutory interpretation?
I didn't catch anything. This all makes sense to me.
Okay, thank you. All right. So just a few other considerations before we go to the timelines. These apply to both the formula and the RFP grants. The funds are available for encumbrance or expenditure until December 31st of 2024. That being said, at least the formula grants have to go out, quote, as soon as practicable. The State Bar has to report annually to the Judicial Council. That's like a separate reporting requirement than the reporting requirement that the grantees will have on their finances and program activities that will facilitate eventual reporting to the federal government. This is just the State Bar's regular report to the Judicial Council. These grants are supported by the Federal Coronavirus Fiscal Recovery Fund of 2021, which is why there will be quarterly or likely be quarterly program and financial reports for the grantees. I think Dwan and Bonnie probably know the nuances of that, but my understanding is it facilitates California Department of Finance reporting to the federal government. We wanted to note that staff at the State Bar is waiting to hear from the legislature about whether programs can or should submit multi-year budgets, or if staff's impression that a one-year budget is most appropriate and expected is indeed what the legislature was expecting. But Dwan, would you add anything?
Yeah, let me add a little bit to that last point. There was a iteration of the budget proposal from the legislature that said that for this funding, we would originally get $40 million over 3 years. That was a few months ago in the building blocks, I believe, a Senate proposal. But the way the state budget, is created, it's on a yearly budget. So when you look at the state budget, we only see the $40 million. So we went back, Selena, as well as Bonnie and State Bar executive staff, to see if we can get some clarity, to get in writing somewhere that we have, we can plan towards the $40 million over 3 years, so $120 million. Then we got the update that's actually no longer $120 million, it's $80 million. So the first year is $40 million, which is in the state budget. And then the 2 years after that would be 20 million and 20 million. It's in like a Department of Finance budget, but it's not made to the public. State Bar staff, Don in particular, I think we're comfortable with the fact that they've given us assurance. So now the pending question to the Department of Finance is, can we take the 40, 20, and 20, the $80 million, and can we issue a 3-year grant so that programs have some assurance to hire, and can we smooth out that amount? So it doesn't have to literally be 40, 20, 20, but can it be 80 over 3 years? We are still waiting to hear back, and that's why I asked Chris to add this bullet point, because depending on what they say, we may be we may be distributing not just the 40 million, but the total 80 million over 3 years.
I want to just add there that to me, part of that is a development of some expertise, particularly in the homeowner piece, because it's very specialized. And even though these legal services programs are doing this work, the number of people that do foreclosure prevention work is very small. And the law is arcane and difficult. So to me, part of this is really the stretching this stuff out over time is actually really essential just to develop the expertise.
Yeah, I mean, we agree. I think, and we've been moving towards a multi-year grant. It just gives programs more assurance to hire a bit more stability. With this type of funding, a year is just too short. So we were hoping to get that by this meeting. Obviously, we didn't get that confirmation. So we will hopefully get that by the commission's meeting to provide you all that update. And if we get it before, then we'll send an email out.
And 2 quick points on that. The person who we've been most interacting with on this is on vacation until Monday. And so as soon as he gets back, I believe it's Monday, because I think Lauren has a call with him on Monday. So when he gets back, he'll be able to answer. When legislature is in recess, staff tries to briefly get a vacation if they can. And the other thing too is I actually saw a screenshot of the Department of Finance access to the multi-year budget. And so I can tell you it did say 40-20-20, but legislative staff does not even have access to that, because only Department of Finance has access to those multi-year budgets. And so when we were asking legislative staff, Donna, Dwan, me, Bonnie, everybody, they'd say, well, I think it's 40, but I don't have access. And so somebody actually pulled a screenshot for us.
And I've had a confirming memo from our contact at DOF as well.
Anything else on this slide, Dwan?
And the encumbrance, because we've been getting that question, what does encumbrance mean? So encumbrance is when the State Bar and the Judicial Council execute the contract, then we've satisfied that first prong. And that's going to happen in the next few months. Bonnie and I are working towards that.
Okay. Thank you. All right, so I think we go into the timelines now. Okay. So there's staff have 3 timelines to show you, and all of them are open for your input. The first 2 timelines are for the formula grants, and there's 2 options. So one option is, and again, the statute says that the formula grants need to go out as soon as practicable. So option 1 presents what staff thinks is the earliest possible distribution of November 1. And then option 2 in the next slide is going to be a December 1. And we take the extra time in that other timeline and we give it, for the most part, just to programs, so they have more time to complete their application and submit budgets. Doesn't increase the amount of time.
Oh, sorry, Chris, before you start, we also just want to note that with the HP1 distribution, there was that practical language that was there, and we did a distribution of October 1st. And so we really tried to, initially we tried for an October 1st timeline. It was not doable. And you'll see as Chris goes through the November 1st timeline, which is also really, really crunched for a lot of these pieces. The October 1st was not tenable. We showed it to Bonnie, and it would give programs literally only like a couple of days to do. It was not a responsible way to distribute the money. So that's
it was going to be like 1 week to apply, 1 week to create the budget. And I think part of the reason for that change was that the governor signed the authorizing legislation later this year than last time, is my understanding. So I'll go through the formula ones first, and then after there's a chance to discuss those, eventually I'll show the recommended RFP timeline. And we actually have a few different ways the RFP one could unfold, but I thought it made sense to just start with the formula. And then, yeah, Eric, what you saying?
Yeah, I mean, in terms of the determination of eligibility, which is a key piece on your timeline here, is staff doing anything there that is different than what they've already done to determine eligibility for IELTA?
So Eric, do you want us to just walk through the timeline? Because that might answer.
All right, you're going to cover it in that way, sure.
So the I'll pause on that, Rose, so we can chat about it. So the commission it has a meeting on August 13th already. So the commission will have that opportunity to to approve the timeline and to delegate authority for any authority as appropriate for the formula and RFP grants. And staff has recommendations in the resolutions at the very end of the slide deck for delegations of authority. The earliest then that staff could release the formula application is August 16th. I think the 13th is Friday and the 16th is Monday. So staff is already working on the application now, and it's almost done. The November 1 release has the application being due back about 2 weeks later. That was the most that we could squeeze in for programs. The reality is because it's the formula grant, the application can be a little bit shorter. It's not a competitive process, and some programs can copy and paste some or a lot of the language from their last formula grant if they got it into the application and speed things up. But 2 weeks is still a very little amount of time for programs with summer travel. So if the program has people out, especially if the director of finance or the executive director is out, that might be stressful for some programs. Just wanted to note that. So staff would start reviewing the applications for statutory eligibility immediately. So it's, September 1 through 10 is only a few business days because it captures the Labor Day weekend. And then the committee, HP Funds Committee, would meet to vote on eligibility on September 17th. So that assumes that the commission delegates authority to staff to review the applications subject to HP Funds Committee approval, rather than the commission votes to approve eligibility. Staff would run the allocations after a finding of eligibility, since the actual amount, by formula that each program would get would be subject to the number of qualifying applicants. Staff would provide each qualifying applicant with their allocation that they would get so that they can create a budget that has to be bifurcated because the amount that they would get is premised on their finding of eligibility. This timeline gives them about 2 weeks to submit the budget, which again might be kind of tight for programs if there's travel or they're unsure if they want to accept less than the $50,000 floor or some amount that's less than the amount that they would be allocated if they need to decide how they're going to hire. And then staff would review and approve formula budgets as soon as possible so that the committee could approve the budgets on October 22nd. And I just put in parentheses, unless the HP Funds Committee and the Commission want to delegate to staff the authority to approve the budgets.
And I think Eric, this is where your question is, the difference between this proposal and IALT and EF application. So the IALT and EF budget review goes all the way up to the Commission for approval. There's staff recommendation to the committee, then the committee recommendation to the commission. What we're proposing here is once budgets come back, if staff can have the authority to approve budgets. It's fairly technical. We're reviewing to make sure that they budgeted for qualifying activities, no staff plantation. So it's all pretty technical. So we would like to have that authorities to move along the process. If you don't feel comfortable with that, then the committee will need to reconvene on October 22nd to approve budgets. But in either case, we'd still suggest that you ask the commission to delegate authority to the committee to make that approval.
So, but I had a slightly different question. So when you are reviewing applications for eligibility, what is that? Are you just looking at the services they propose to offer to see whether they fall within the statutory definition of homelessness prevention?
I mean, that's the bulk of it. There are some other questions that we built in because there's some technical requirements like we need their DUNS number. We need them to understand that there's quarterly reporting. We need them to verify that there's no supplementation. So it's a little bit more involved than that, but the bulk of it, the substantive piece is a question of, do you have qualifying activities? And that's the one that we review very closely to make sure.
And just one thing to sort of point out, because it's not obvious from the way the table looks, is there's some gaps, like for instance, between September, after staff determine or reviews for eligibility by September 10th, the committee meets a week later. And as most of you already know, that's to facilitate Bagley-Keene NIP public noticing requirements and staff having time to create that memo and post it like at least 5 days in advance, that sort of thing. So this is like the tightest timeline we could come up with where all the proper steps still happen. So October 1 was untenable, but November 1 was as soon as practicable for staff and the committee. And then the next slide is, we think, kinder to applicants. So we just took the extra month to December 1 release, and we gave almost all of it to programs. So they would have 4 weeks instead of 2 weeks to create their applications, and 3 weeks instead of 2 weeks to submit their budgets. And I think we built in a little time to do like a webinar in late August where we might have more guidance to provide to them and be able to answer more of their questions later in the month than earlier in the month. Otherwise, the sequencing is the same, the roles are the same, and the amount, more or less the amount of time for staff review is the same. Selena, I know you had thoughts about the timelines for the RFP, or sorry, for the formula grant. So feel free now if you'd like to.
Yeah, I just want to say, I assumed wrongly that programs would want the money. Can you hear me okay with this, with the microphone? Okay. I assumed wrongly that programs would want the funding more quickly because I thought that perhaps hiring at year end might be tough and that they would want the funding more quickly to kind of ramp up. But I spoke with my board, which we have 18 members of our board from across the legal aid community. And many of them responded back and said they had a very strong preference for December 1st start date, specifically because even though I understand that the application period will actually be pretty easy because the formula application is pretty simple, a lot of them said that many senior staff were taking vacations in August. And so having more time on the front end would help them make sure they had time to talk with community partners and vet the projects, specifically because of the no slow plantation issue. So my assumption was wrong, that at least of the organizations I spoke with, they had a preference for December 1st start date. It also, they said it gave them more time to kind of think through their projects as well.
And then if it wasn't, thank you so much, Selena. And if it wasn't obvious, that we highlighted in yellow just the proposed committee meeting dates. So that just designates a committee meeting. Dwan, was there anything you wanted to add to either of these timelines?
No, we're just really curious to see your thoughts on both the timeline and the delegation of authority pieces.
Yeah. And then Bonnie too, I know you had an opportunity to weigh in, and I don't want to speak for you, but you're the one who actually caused me to realize that the November 1 release might be stressful for programs, because when I worked that one up, that hadn't occurred to me.
Yeah, yes, I just think that if it isn't a huge need for them, that it would be better as to allow them time to actually think through again, because of the no supplantation issue and thinking about outcomes that they're going to be able to report and things like that. So I appreciate that opportunity. And thank you, Selena, for checking in with the programs, because that's really, the critical thing to my mind.
Agreed.
You have a minor interference in the September days for the Jewish high holidays, which are September 6th through 8th, and then 15 through 16.
6 through 8 and 15 through 16.
Right.
Okay, thank you. Let's see. Right, so okay, that would be, so for the November 1 release, that would have only posed an issue for staff in that programs, but right, because we push out the due date for the formula applications, it now coincides, the 6 through 8 coincides with the due date. And then 15 through 16 will impact staff, but not programs, since it will be staff's review of the applications for eligibility.
Juan, on the delegation of authority piece, I'm sorry, could you review the issue there one more time? I'm not quite
So there's two delegation of authority. One is to ask the commission to delegate authority to the committee to pretty much approve eligibility and budget. And the second is to ask both, with that, the staff is asking both the committee and the commission to delegate authority for us to be able to approve, the staff to be able to approve the budget.
So those are two separate items you want delegation on. Yeah. Well, I mean, I fully support that. Because they're formula grants.
Agreed.
Yeah. I also support pushing the time to December 1, even before I heard the vote from Selena, because it just seemed like summer and 2 weeks. And even though it's somewhat some cutting and pasting, I think it's just not enough time. I mean, I think programs are still trying to figure out how to deal with post-pandemic and more epidemic. So I think as long as we meet the terms of the legislature, you know, as soon as practical, I think I would support the later date, the December 1.
I'm inclined to as well, but is there sort of an out, Duan, if there are any budgets that present issues of policy, or that may not happen actually, but most of the time budgets are pretty straightforward. But so I'd kind of be inclined as well, but is there any out for kind of discussing if there are any?
Yeah, I don't anticipate any issues at the budget level. And honestly, if it's not something that like we actually would feel comfortable approving, we probably would then call an ad hoc meeting and ask you. If there was something that was surprisingly like an outlier, and I didn't feel comfortable approving it on staff's behalf, then we would come to you. Or we'd probably come to Chris first. We're actually the new chair at the time, and ask to see whether it would be appropriate.
I think the committee has an existing meeting. The RFP timeline shows this one doesn't, but it has an existing meeting on November 10th, but that's to discuss something different. It's like budget modifications and carryover requests, and you probably need all the time for that. But there is a meeting on November 10th, which perfectly comes at the end of staff's review of the formula budget. So there's that too, but I think that meeting would have to be longer than it probably is right now if we were to do something like that.
Jim has his hand.
Yeah, on the option 2, how does that December 1st start time compare to the last round?
So there was similar language in HP1 application. So in 2019, we distributed the formula October 1st. And so that's why Chris and I, when we first mocked this up, we were striving for the October 1st, because that's what we did with that piece of legislation. It just was not tenable. And do we have any feeling at all whether or not the legislature would be okay with the December 1st being later than last year's? You know, we didn't ask them specifically, but I feel like with all the reasoning that we just, you know, because feedback from program, to do it responsibly, I don't think they would have a problem. Bonnie, Selena, do you have any thoughts?
I don't have any indication that there'd be a problem. I think Selena and Lauren have been talking more with the legislature.
I agree with Bonnie and Duan. I don't think that there would be a problem, because I think that we can make it really clear that this budget year was part of the reason why there needed to be a delay, is truly understanding what the funding is. And everyone who is involved understands how weird this budget year was. And that I think if this committee had, you know, set a meeting on July 10th and had moved forward with an October 1st start date, that would have been, you know, very presumptuous, because you didn't even know what the administrative cut was at the time, and they were still working on the budget. So I think that it was very prudent to wait until meeting now, and also just like getting more information. Yeah, I mean, it's not just the fact that the governor signed it a few weeks later. The last time we had a heads up that it was more than likely not going to happen. And there wasn't also competing HP legislation. We just didn't know where we were at in June to be able to do that. Last year, we knew in May. And so I don't know if you all recall, but we actually emailed programs the last time in May and gave them tentative awards, because we knew it was pretty much going to happen. And so there was a pre-meeting with this committee and the commission to plan towards that. We didn't have that because everything was up in the air this time. So it wasn't just the governor signing it 2 or 3 weeks later.
Well, and this is also, if we'd met on June 10th, we would have been trying to figure out if partnership grants would be coming out of these funds, and how we would be allocating 10% of partnership grants, 25% of formula, and or 75% of formula and 25% of RFPs. So that was the other challenge that needed to be resolved, and this is why this is the third budget. So
yeah, so that what Bonnie's alluding to is the other iteration of this budget, SB 128 and 129 had a carve out for partnership grants, which was very odd, and we knew it was a mistake. It's just that until this iteration they took it out.
Further discussion on the formula timelines? Okay. And again, these timelines build in certain assumptions about the delegation of authority from the commission to the committee and to staff, and then we have resolutions at the end that we can modify if necessary, but that capture what's in these timelines. Okay, so I'm going to advance. So before throwing up the RFP timeline, we wanted to flag that staff have identified 3 possible approaches. I'll flag for you before showing you the timeline that it's going to be a proposed January 1, 2022 distribution. And so the timing is a little less tight, but only a little bit, because it's, you know, December 1, November 1 versus January 1 and the holidays in there. It gives us a little bit more time, but the scoring process is far more rigorous because it's a competitive grant. So the 3 paths that staff see is one is staff reviews the application and reports to the HP Funds Committee on its scores to justify and seek approval for those scores. So that would be a staff-led process. We wanted to propose that, and we'll kind of flesh out this recommendation in a moment, because as you're about to see, the timing of a committee-led scoring process is really heavy in 3 weeks of October. And so the timeline we worked up actually will show that. So number 2 is the committee scores all applications. That's the timeline you're about to see. And then a third option is a hybrid of 1 and 2. For instance, maybe it's a working group of staff and 1 to 2 committee members that score the applications and then report back to the full committee. So to be conservative, we worked up the timeline to show what it would be like for the committee to participate in all of the scoring. But before I show it, was there anything staff or Adjourn you wanted to?
Yeah, I do want to add that, you know, the staff recommendation is to go with 1 or 3. 2 is the status quo of what we've been doing in HP grants. 1 is more similar to what we just did for the provisional licensee, the PLL grants, and we thought that was a really good use of both staff's time and the commission's time, you know, with helping us create the rubric and but having staff score. I did, because Bonishay couldn't be here today because she's in trial, I ran through these options with her, and she just wanted me to express that her support was for number 3. And if we did go with a hybrid, that she could volunteer to be one of those 2 commissioners. So I wanted to share that with you.
Okay. Just like show you what it looks like. So this is option 2. This would be the status quo option where the committee is performing the scoring. So it's the same meeting of the full commission on the 13th of August to delegate authority and approve the timelines. The commission or committee, and we would recommend that the commission delegate to the committee the authority to approve the RFP, including the scoring rubric, by the end of August. So if that happened, this committee would meet again at the end of August to approve those. The RFP would then go out as early as possible. So if the, you know, I mean, ideally, if the committee can meet by August 31st and there's approval, we'll release the RFP on September 1st and give programs 1 month to submit their competitive proposals. The committee would then participate in all of the scoring. What we think that might, in October, what we think that might look like is the committee would calibrate to the rubric at least 3 to 5 applications. So this timeline gives 1 week to do that. And then this timeline gives 2 weeks post calibration for committee working groups. So the committee would calibrate as a full committee. Then it would break down into working groups to score the applications. We're estimating about 15 applications per working group. And the working groups would probably perform their scoring over at least 2 meetings. So this assumes 2 meetings. So that would happen in 2 weeks. And then the final week of October, the committee would come back together, discuss the applications, look at all the scores as a big group, everything together in context, and finalize its award recommendations. We've put in here, just so that you can see the committee's existing workflow, how this all slots in. The committee has a meeting on November 10th to review budget modification and carryover requests for the 2021 through 2023 HP grants. So that meeting would not, under this timeline, handle this batch of RFP grants, but we just wanted to show you that there was another meeting in there. And then since the committee would be meeting on the week of October 25th to actually finalize its recommendations, the commission would then be able to approve those recommendations at its meeting on November 17th, which is an existing meeting. And then the end of November through December would be grant agreement signing and processing the invoices for a January 1 release.
And the one thing this calendar is missing is that other October date for the formula grants that you would be meeting.
Right. So yeah, so the formula grants would be happening at this, yeah, exactly at the same time. Yeah. So so if the committee and commission didn't, for instance, delegate to staff approval of the formula budgets, which it sounds like the committee is leaning towards, there would be a meeting in October where you would be meeting about the formula budgets. Okay. Any questions or concerns about this timeline? We had a little bit more time for it to look like the normal amount of time that the programs would get to submit a competitive application, and there isn't a separate need to review budgets like there is for the formula grants, because for the competitive process, the programs will submit their budget with their original application. So application scoring and review will handle consideration of the budgets at the same time.
And we also thought that because they're the competitive grants and they're obviously more competitive, that the commission should be the final approver for eligibility, unlike the formula.
There's less delegation of authority built into this timeline, unless the committee, the HP Funds committee, wants to recommend to the commission a staff-led scoring process or a hybrid staff commissioner process. Then we would build into the resolution a delegation of authority for that. Okay. I think the next one is the resolution. So before everyone starts reading this, was there anything else, Dwan or Brady or Selena or Bonnie, that's helpful context?
I don't have anything to add. I just am very curious about what you all think.
Yeah, I guess I'd be curious to know I think all of us participated in the last process, which would be duplicated by the timeline that you're putting in here on the slide, as opposed to the process that would delegate more to staff. But did people feel that there was value added from that rather intense process of small committees and then calibrations and I don't know. It was a lot of work.
I thought it was a big step forward. I don't think we're ever going to get to perfection because everybody analyzes the applications and the goals of the different RFPs differently. But I thought we had a stronger foundation, and yes, it was a lot more work. I think but I'm happy to do it again, even though it is a lot of work. I think for me, where I think we really need to put in some thought is the scoring rubric and the articulation of that, and several issues that came up that have been mentioned today, which we didn't address previously, one of which is sort of my thing, which is I think we really need to put a cap on the amount that that a program can ask for, because there were some wild budgets in there. So for me, what goes on, if we go with this timeline, what goes on between today and August 31st, to me is really, really a really important part of our work.
I agree with Kim's comments, and the one advantage I'm uncomfortable with option one, as great as staff is and as easy as that would be. Frankly, I mean, I'm sure you guys would make great decisions, but I'm uncomfortable with it. The thing about option, and I like what Kim said, I think there would be value to option two, but the thing I like about option three, selecting two commissioners, is that those two commissioners would have visibility to all the applications, right? So I think there is some value to that for consistency. I could be persuaded by either 3 or 2. I'm not in favor of 1.
I'm fine with 2 also. I didn't realize my comments came across as that I was going for that option. It was more that I think the investment in time was helpful, particularly in terms of seeing if the different committees were evaluating it in a certain way. I think it's really up to this group to decide whether they want to have just 2 commissioners be reviewing everything.
Yeah, I'm curious how you came up with the number 2.
It's part of it is
commissioners.
also Bagley Keene. We didn't want to approach a quorum so that we'd have to, the process of calling another meeting. And so we kept it to a safe number too.
Well, I don't mind having a smaller number as opposed to having the entire commission or the entire committee. But I think 2 is a little small, but I think it's important that the commissioners are involved with actually scoring these grants. Otherwise, how can we provide feedback on scoring rubrics and stuff? I mean, you actually have to use these things in order to provide feedback, in my opinion.
So I totally agree with you. I think we love having you guys on. I think the biggest deficiency of the status quo is that you're reviewing a subset. So I think in an ideal world, if we had more time, all 8 of the committee members would be reviewing the entire set with the staff. I think that would be like the gold standard. We know that's not tenable. I think that's something that I brought up in the rules committee, having the commissioners review the whole set the way staff do, because then we're on an equal playing field. That I don't think that's the direction you all want to go in. If it was, then that would be a full staff support recommendation and path. Not being able to do that's why we were inclined. But I hear you about the 1, and part of it is, and I'm just going to be really, really blunt now. All of these timelines, it's a hardship for us. I mean, Chris is going to be modest, but Chris, I, and Erica have been working till 11 or 12 the last few weeks. This gives us a little bit of a breathing room, having be a bit more staff led. So if you're not comfortable with that option 1, then I'd really suggest the option 3, just to give us a little bit more breathing room and not having as much meetings.
I just have one question. I'm sorry if I missed it. How many applications total are you expecting based on past years?
Based on past years, about 40 or 50. I just don't know if that's the amount, but that's how we divide in 4 working groups. This committee is 8 on purpose so that we can divide out into 4 working groups. So 40, 50 divided by 4. So we said roughly 15.
Nice cat, Selena.
That was very cute. It's like a Halloween cat. Is it?
Are we to the point at this stage where people want to talk about it, or is there a sense that people have, know what we want to select, and then we sort of move in that direction officially?
Sorry, can I ask, Chris, can you go back to the option 1 on the screen?
Yeah.
Thanks. If nobody else, I think we're going to be. We've had similar discussions in the Rules Committee, as Duan mentioned, as we're kind of going through a review of this process, generally, not for the HP committee, but just generally across the commission. And I think the challenges that come up with the timing are really the one of the driving forces in having a certain level of flexibility. In my view, I think it makes sense to kind of tailor what we're dealing with to the constraints and limitations that we are presented with. I agree the ideal would be everybody scores everything. I don't think that's realistic, especially here. My view is, I think I'm inclined to option 3, but I also think that there is value, and the reason that I think 1 might be more preferable than option 3 in at least one respect is that then the full committee can sort of weigh in on all of the scoring. And I think we've gone through this process. We'll be a part of putting together the scoring rubric. And I think in that sense, we'll at least have a familiarity and understanding of what the priorities are and be able to then review what staff has done at a closer level and be able to kind of have visibility and access to address all of the applications. So that's kind of where I am. I'm a little bit on the fence, but those are my thoughts.
Jim?
Yeah, you could have another option, sort of a cross between 1 and 2. That is, you could have the entire commission review 3 to 5 grants and score it and go through the meeting with court scoring consistency. And then based on that, then have the staff pursue option 1. That is, they would score all of them and then come to the commission. That way, at least you have entire commission participation in the rubric and consistency, and the staff would be involved with that so that they would have a feeling in terms of how the commissioners would score the other 45 grant applications, just as an alternative.
Jim, do you think that's better than 3?
Yeah, because as was mentioned earlier, that involves the entire commission. Everybody's involved with getting a standardized rubric involved. But the entire commission is only reading 3 to 5 grants.
You say the entire commission or the committee?
I'm sorry, the committee.
Okay.
Yes. Sorry.
Juan, can I ask, you and Chris, do you have a preference between 2 and 3? You have a preference for 3 because you feel that the timing of the meetings and whatnot is burdensome. Is that right, or is there another reason why number 2?
Yeah, I mean that's mainly the extra working group meetings. It just takes, it's more work for us to coordinate and then for us to prepare for you all. Whereas we have the standing meetings. The way staff does it, just so you all know, if this is not obvious, is there are always in any given competitive grant 4 staff eyes on every grant. So we review the whole set. So on this particular grant, it's Chris, myself, Danielle, and Dan, who you all know are the 4 reviewers. So what we do is we go through and everybody reviews the whole set, and then we have a calibration session, and then we split up where we are responsible for like reporting out on our set, but then we go through and we individually score, and then we come back as a team, and there's not consensus on a lot of them, and then we have to hash it out the way you all do. But that's done at we meet literally probably every other day for 2 or 3 hours to do it. So it's just easy. We have that process. So we do that anyways. And so that's why it's easy for us. When we layer that on with the working group meetings, it's 2 to 3 hours, 2 meetings, and the preparation to then roll you guys in. It's a lot of work for us. I'm not saying it's not worthwhile. If you all think that that's the best way, we are happy to do it, but it is a lot of work for us. And also keep in mind, this is on top of the formula grants, and partnership is going to be happening at the same time, and we're short staffed. And so that's my plea, is if you're not comfortable with 1, which I'm sensing you're not, then to either do 3, and I also really like Jim's suggestion. It just gives us a little bit more flexibility. So instead of working 60 hours, maybe we'll be able to work 50 hours.
The only other consideration I would add is the timing of the 3 weeks in October is just tight enough that if there were delays, like a working group couldn't meet for some reason, somebody had the family emergency or something, and they couldn't meet, or the committee couldn't meet. There's not a lot of wiggle room for delays to meet a January 1 release, unless we take a little time away from the application window. So it would just be that work would be 95% need to be concentrated between October 4 and 29.
I like Jim's suggestion a lot.
This is Rich. I am a little bit concerned about historically what happened in our rubric situation in developing our rubrics, because I think we had some pushback from commission members who were told about the rubric and the effect it had on grant making after the grants were made. On August 13, the committee is sort of launched in its effort to develop the scoring rubric. We have to approve it at that point. The commission won't know about it, and yet it's going to approve it on November 17th. And I expect that at that point, those who advocate for certain groups that are getting less money are going to complain about the effect of the rubric on the ultimate outcome.
Sorry, Rich, to interrupt you. Somebody has a little bit of background noise. It sounds like it could be like a lawnmower or a leaf blower. So if you're not Rich, maybe mute yourself. There you go. Perfect.
No, it wasn't me. I have a dog in the background, but can you, anyhow, my point, I guess, that to reiterate it just briefly is I don't want to exclude the commission from participating in a discussion about how the rubric will be structured. It's not going to be that different from past rubrics. I couldn't imagine that it would be. And I think we ought to try to be inclusive in discussion with the entire commission before we set out using a rubric that would subsequently bring some questions from other commission members who are not on the committee.
If you're on agreement with that, then what we would need to do is then either try to, I mean, we're not going to be able to meet before the August 13th, but then so we would have to require the commission to meet again, which is, if you feel that that's important, we can certainly have the commission convene to approve the rubric.
Does the commission have to approve the rubric?
Well, that's what we're at. Our staff suggestion is the commission should delegate authority to the committee, but I'm hearing Rich say that's important for the commission to approve it. Maybe I misunderstood Rich's point.
Yeah, my vision, Eric, is that the committee would present to the entire commission the scoring rubric, our experience in use of that rubric in the past, and ask for any questions before the rubric works its magic and excludes pet programs that commission members will then say, well, why did that happen? If I had known that, you know, I would like to be inclusive in this to some extent, but I think the committee should approve a rubric, make the presentation to the commission, hopefully get approval from the commission at that point to go forward after some discussion, and then do our work.
I guess, Rich, just responding to that, it feels to me like, I mean, adding that layer, I think it would work if we were talking about something that is not going to be so abstract. I mean, I guess my concern is that any report about the rubric to the full commission is not going to really be able to identify at that stage who would or wouldn't be excluded or what the nuance. So, I mean, I guess like just putting myself in the position of a commissioner hearing a report about the rubric, isn't it always going to just sound fine? Like,
yes, like Chris, that's the idea.
But how is that? I mean, in other words, how is the full commission's approval of that helpful? I mean, I get the education / informational piece, but I guess I'm wondering what benefit beyond that there is in terms of you know, the creation or the sort of structure of the rubric.
I don't mean to sound harsh about it, but on November 17th, we're going to be presenting, the committee would present to the commission the outcome of the application of the rubric to the applications for grants. And there will be some on the commission who see that the effect of the rubric was to exclude or reduce the amount of grant to one of their pet projects or to one they feel especially aligned. And I would like to be in the position to say, we discussed this back on August 13th, and you know, it was agnostic as to how it would impact any specific organization. And this is simply the way it came down. And by the way, a majority of commissioners voted favorably to apply it.
You know, I think there's always this tension between, you know, the committee and the commission in terms of delegation. And I think the whole point of having these committees is to remove from the full commission a lot of, you know, these agendas that have these incredible details on them. So, I mean, my feeling is that the full commission does not need to approve the rubric, and that there's enough of a committee, a lot of whom have been spending a lot of their time on the commission working on bank grants and whatever, that there's, that there's a knowledge and hopefully a trust that we're have developed a rubric. But I think we're going to get very bogged down if we take the rubric to the full commission, and we are supposed to be moving along expeditiously.
I mean,
yeah, I tend to agree with Kim, and I think there's a couple of things that come to my mind. One is the timing. I think if we're not able to sort of put this together in the next 2 weeks, then we'll have to call another meeting of the commission, and I don't know that that's. I think that'll add a hardship. I think also, potentially a reasonable response that we could still use is that the commission delegated this authority to the committee, and by virtue of that, that has accomplished that the result, which is that the commission has sort of given this over. And I think the other quick point to make is simply, this rubric is not a scientific rubric. I think there's going to be a lot of kind of massaging, and there's a certain art to it. So I think also I think we should also keep in mind the idea that, and I think somebody might have mentioned this, I think Chris, you may have alluded to this, which is it may not have an impact one way or the other if they know what the criteria are, or the scoring point values are, because we're going to be kind of assessing projects versus other projects and kind of going through this whole process, that knowing this in advance may not have a meaningful impact.
Also, I think we can say on November 17th that, we used as a basic starting point the rubric that we used last year and incorporated into that rubric lessons learned from the process. So that's not going to give everybody complete comfort, but it may be sufficient.
I guess I'm wondering whether we can, and I just don't know if this is possible, but during the first time, what we did was we had within the committee, we had sort of a check-in session, and we sort of recalibrated scoring by, I think we characterized the initial scores as sort of just that pre-calibration. Joanne, do you remember that?
Yeah, it was that long meeting where we recalibrated that. So that would be akin to this. Usually it's that 4 to 6 hour meeting. That's the meeting at the week of October 25th to 29th. So in any kind of option you choose, we're still going to have that long meeting built in so that we recalibrate, tackle big issues, pull applications, and review them closer together.
I guess one idea that it occurs to me to sort of satisfy Rich's concern is that if we do have that long meeting of recalibration, we could actually convene a commission meeting in advance of that, a brief one of some, let's say an hour, just to open dialogue from the full commission about any sort of pre-calibration statuses. I mean, I mention that only because if I'm trying to get at, Rich's concern that there will be issues with a final report come November without an intervening opportunity for the full commission either to weigh in advance or to weigh in on some sort of progress. And I guess one idea would just be to give the full commission an idea of sort of where we're headed, flag any issues, and then we step into the calibration meeting informed by the comments of, potential comments of commissioners who are, offer questions or, concerns.
Well, as an alternative, couldn't you just say the August 31st meeting to invite all commissioners who are concerned about scoring rubric to attend to that one?
Yeah.
And then that puts the onus on them. If they're concerned about this issue, they'll show up. If they're not, they've had their chance.
I mean, I want to get it back to this idea though about the abstraction. I mean, I think like there's a CYA element involved of doing this sort of in advance, but I also think it's less useful because it is abstract at the outset. It's very difficult for, let's say, a commissioner to sort of appreciate how a rubric will be applied in practice. And so I am sensitive to Rich's idea that, you know, come November, you know, it feels like a fait accompli after all that work has been done. An adjustment out of the November meeting by the full commission feels, you know, less likely. And the statements or concerns of a full commissioner would be more impactful potentially during the process as opposed to certainly at the end or at the outset. Anyway, that's just my 2 cents on that.
That seems like a departure from the way we do our RFPs generally. I mean, we delegate to committees, committees make recommendations, we bring them to the commission. Bringing the commission in at the pre-calibration stage sounds kind of cumbersome to me.
I'm a little bit worried about the slippery slope that this creates about how, and I think, Eric, you're getting to this issue, which is, you know, when we set up this process, it's set up in such a way so that for a variety of reasons, the entire commission is not participating in the sort of deep analysis of all of the different RFP applications and the programs and everything that's going into this, and then ultimately or have been delegated with the authority to do that deep review. And the committee is sort of in the best position to make these decisions. And I think where we're sort of catering to potentially a commission member who may have a preference one way or the other for a particular program, I think sets kind of I don't think it's a good precedent that they would be able to then influence an adjustment to that program simply because they have a personal preference. And if we do it sort of in a way where we say, and I like the idea of maybe inviting them to the committee at the outset, the committee meeting at the outset, so that if they want to raise whatever they want to raise, but I do think that we should be careful about how much input they have, because at the end of the day, while they may have a preference for one organization, they haven't seen the other programs, the other applications, they haven't really done the deep work. And I think for that eventuality or outcome where awards are changed at the last minute because somebody has a personal preference, I think it's dangerous.
Well, I'm going to step into some defense here of Rich. I don't think Rich was suggesting something quite so untoward. But I would say, I don't know that commissioner's statements in the, first of all, I don't disagree with any point Eric or you just made. I mean, with respect to the process, I think it's not necessarily the case that a commissioner is going to try to influence something, but I do think a commissioner could raise a question or concern. It could be influential, but it's not necessarily the case that that would be their intent or they would be trying to influence. Just to be clear, I actually don't feel strongly either way or really about this schedule and any adjustment to it. But of the options that have been sort of put out there, I probably like Jim's the most, which is, you know, commissioners be invited to the August 31 meeting and let them weigh in at that point in the development of the rubric, and then we, you know, hit the ground running in the normal course of, or the normal sort of path, traditional path.
I mean, I agree. I think that Jim's idea of having an invitation out to any commissioner not on the committee who wants to come is a good idea, and either they show up or they don't. And then when it comes to commission approval of awards on November 17th, you know, you had an option to come if you wanted. And I think it doesn't I mean, I'm very sensitive to what Amin said and kind of, you know, philosophically lean towards him, but given some of the discussions that have gone on the full commission, I think that Jim's idea is a good nod to disclosure and inclusiveness. But I sure don't want to set a precedent on this. I mean, the whole point of having committees is to delegate and that we put our trust in those committees, because if we start making this a practice, then we've got Amin's rulemaking committee being subject to oversight by the full commission and nothing ever gets resolved. So, I mean, I would say for this time, if there's really a concern, that we go with Jim's idea and invite people to come. But otherwise, I really don't think it's necessary, but I'm certainly willing to support that if that's what most people want to do.
Can I just jump in for just 1 second to sort of, I don't mean to suggest that anybody, that the suggestion is that there is an interest by anybody to make decisions based on their personal preferences, or that anybody on this committee or the commission is inclined to do that. I just think the precedent is the issue, and I think it's a slippery slope. And I don't want us to get into that territory. So that's the context for my.
Let me make one final pitch. I have a fallback and a default if I lose on this round, and that is that Kim is going to chair the meeting on November 17th. But here's my final pitch.
We're co-chairs.
Yes, I know, but one of us is going to have responsibility, and it's going to be you if I lose this. I'm only kidding. The one thing that has to be inviolate is that when we present on November 17th, if a group of commissioners decide the rubric was unfair to rural applicants or unfair to Northern California or whatever, and there's a rebellion and we can't get a majority vote, it will appear as though it was outcome driven. And I think we have a duty to the grant applicants to make it inviolate. The process of selecting the values in the rubric has to be free from any influence at the end as a result of the outcome. So that to me is the big thing we want to protect against. My idea was a totally political idea, and that was we present it benignly in the beginning at the August 13th meeting. We just say to them, this is a rubric we're going to use. We may massage it when we meet on August 31st, but generally this is where we're starting from. And so do you have any thoughts or discussions about it? No outcome has been revealed because we don't even know what the grant applications are. It's completely agnostic as to any one particular group. The result of that is that we've included them on the 13th and they have a shot at it. And we can always say that on the 17th, we discussed this with you. If you had a concern, you might have raised it then. We don't want this to appear outcome driven. The result is we're going to stick with what we presented to you unless there's something really egregious. That was my point. That's my final pitch. I don't really feel too strong like Chris does.
Duan.
Yeah, Chris went to grab his cord. So I'm actually, I can go either way with the commission weighing in, but the August 13th though, Chris is preparing a really fleshed out memo. I don't think we'll be able to we're not going to be able to have it for the August 13th meeting. So I'm just a little hesitant to kind of open a discussion on August 13th when we haven't done the pre-preparation for it. It might give us an appearance of sloppiness and unpreparedness, and that would make me uncomfortable on behalf of the staff. If we were going to call a commission meeting, then if you all felt strongly, I would suggest then before the end of the month, but not August 13th. We just can't put it together and quickly enough to do.
I was suggesting August 31st.
You were suggesting just inviting commissioners to attend August 31st, right?
Not a separate meeting, right, Jim? Just inviting the.
Yes. If you're concerned about the scoring rubric and how it's developed and how it might be applied, attend the August 31st.
Yeah, Rich, why doesn't that satisfy your political concern?
It does. That would work fine. Jim's idea is a very good suggestion. It would work.
Right.
And then Eric, did you have a?
No,
I
no,
see your
that-
hand still up.
no,
Okay.
no, I'm done.
So we might need to do a slight edit to the resolutions on the next slide to if the committee is leaning towards recommending a hybrid scoring process. But before I move to that, was there any other questions or concerns about the timeline? Okay, and then Dwan, is it your preference that I make an update to this table that's on the slide right now, since the resolution refers to committee approval of the timeline?
Am I sensing a leaning for Jim's hybrid suggestion? I personally really like that idea myself, and it didn't occur to us. I really actually love it, because then it does give every committee member the chance to review the 3 or 5, make sure staff is reviewing it. It's, it helps us with not as many meetings. It gives you guys all equal footing. I really love it personally. That's my sense, but I don't want to assume. Is that
I share the view.
Yeah, I do too. The folks that would attend that meeting would not be voting members of the committee.
No, they would.
Why? They can influence the outcome. They can make their pitch and argue why we are valuing something higher than it should be, whatever. But do they become voting members?
Oh, I think we're talking about 2 different things. Sorry to confuse everyone. So I think what I was hearing with that the issue is we're on agreement with inviting the commission to the August 30th first meeting. So I don't think that's controversial. I guess what my point was about how do we do the application review? And I was saying that I was in support of Jim's suggestion of that hybrid, where we select perhaps 4 or 5 applications, and the full committee will review it and calibrate it alongside staff. And perhaps then we call a meeting that first week of October there, so that you all can feel comfortable with the way staff has calibrated, because you would have already scored it yourself. And then staff will then go on to do our scoring, and then we would reconvene for a long meeting where we can discuss the staff recommendation.
I'm in favor of that.
One modification, since we're going to create the standardization of the committee as a whole, and then the staff would be scoring all the grant applications. I think we should have a fallback if the staff are in conflict amongst themselves on a particular grant or a particular scoring, that they come back to maybe a subgroup of the committee to hash that conflict out.
That's what we were anticipating. If there were, this happens every year. There are a handful that it causes a lot of disagreement, and those were the ones that we would flag for your more detailed review.
Okay.
And I think maybe just we could throw that to the whole committee, and maybe not a subset.
Yeah, I agree with that. And to answer Rich's point, I guess, Rich, you were talking about the August 31 meeting. Yeah, I think only this committee would be voting members at that meeting, if that's what you were concerned about.
Correct.
And I also just want to agree with Kim's comment a while ago about, I do think like the most important part of this is really getting clarity on the scoring rubric and hashing out all those kind of policy decisions, so that when we go into scoring, we have a really good, clear picture of what we're scoring. So with that said, we were going to reach out to Jim for some help on the scoring, but if there are other commissioners committee members that would like to work with staff on this before it comes to August 31st when we meet as a committee, then let us know, and Chris and I are happy to preview kind of some of our suggestions in advance of that August 31st meeting.
So correct me if this is wrong, Dwan and Christian, but I actually, looking at the way we've worded it, don't know if we need to change anything in the October rows committee. What I heard, if we were going with Jim's suggestion, which I heard some people supportive of it, was the committee would still meet as a full committee to calibrate like at least 3 to 5 applications, and that would serve as to provide staff with guidance, or a staff commission or working group with guidance as to how they ought to continue applying this rubric. And then the staff commissioner working group, this is the hybrid model, would score all applications and then come back to the committee.
Oh, actually, I think you cut out, if under if I'm understanding Jim's suggestion, we don't have that's working group score application. That would just be staff scored.
Okay.
You just cut out that line. But we still reconvene at the end of October for that long meeting. And then in advance of that, we'll flag the ones that are a bit more controversial. The staff is not in agreement, or for some other reason, there might be issues.
Okay. And I think everything else can stay the way we've already worded it. All right. Is now a good time for me to display the resolutions, proposed resolutions? Okay. So this is, and Dwan and Brady, let me know if you have a preference. We had married these together into a single resolution with, it just has further resolves, but it would be one vote. But of course, the committee can vote on these separately if it wants. We can do 4 different votes, but there is the option, I believe, of being able to do it in just one with the further resolved language. So I'll read it out loud, and I think we're going to need to edit a couple of things as we go through it, at least to reflect, for instance, the December 1 timeline for the formula grants, if that's what the committee wants to recommend. So this would be this would turn into a recommendation from the committee to the commission for the August 13th meeting. So resolved that the Legal Services Trust Fund Commission Homelessness Prevention Funds Committee going forward approves the proposed timelines for 2021 homelessness prevention formula and 2022 HP competitive grants. So the distribution year is what goes into the name of the grant. So 2021 would be for the formula, 2022 would be for the competitive. And I think, Dwan, do we need to specify that it, do we want to specify that's the December 1 timeline since we presented 2 options? I could
Can we
propose
say
December 1, 2021 timeline for the homelessness prevention formula.
Yeah, we probably should specify it.
I could say, let me know if you want me to do this differently, but the December 1, 2021 timeline for 2021 homelessness prevention formula and January 1, 2022 timeline for the HP competitive grants.
Yeah, I think that works.
It's a little wordy, but, and then Brady, let us know if you can think of a cleaner way of doing this. And so approves the December 1, 2021 timeline for 2021 homelessness prevention formula grants and January 1, 2022 timeline for 2022 HP competitive grants. Let me know if I'm going too fast. We can always come back to that one. Further resolved that the committee recommends that the commission delegates authority to staff to review and the committee to approve eligibility and allocations for the 2021 HP formula grants. Further resolved that the committee recommends that the commission delegates authority to staff to approve the budgets for the 2021 HP formula grants. And it is further resolved that the committee recommends that the commission delegates authority to the committee to approve the request for proposals, including the scoring rubric for the 2022 HP competitive grant. So that would be the August 31st meeting. And then this was in case the, depending on what the committee chose as the approach to scoring, we had and to staff to score applications in consultation with the committee, which is what it sounds like the committee has elected. The alternative was that the delegate scoring to just the committee, but not staff scoring. So I'll leave this up for a moment so people can sit with it, read it a couple of times if you like, and I won't rush you. So if I need to make it bigger, let me know.
When you say score applications, aren't we doing more than that? We're also approving grant amounts as well, right?
No, the full commission, that's the one we didn't want to go out of process because we felt like it was important to keep that as a commission approval.
I see. Oh, that's right. That's the November 17th meeting.
Mhm.
Yeah. Okay.
So for the RFP, it's, yeah, the commission retains ultimate approval of everything. The pieces that it would be delegating that it might not have to delegate would be approval of the scoring rubric or an RFP, And then specifying that staff may score the applications provided that it does so in consultation with the committee.
In the last bullet point there, is it correct that for staff to score applications in consultation with the committee as opposed to the staff and the committee to score applications? Or am I overstating?
Well, if you're changing it to staff and committee, that's the status quo. I thought we were comfortable.
Oh, I see what you're, okay, yeah, understood. Sorry about that.
I'm ready to move adoption.
I pulled up my voting slip.
And Chris, would it be okay with you? We just take in one motion? I think Chris froze.
That question for Christian. Sure.
Yeah. Oh, I think Christian froze.
He was paralyzed by that suggestion.
All right, has everybody had an opportunity to read the resolution?
Yes.
Any further questions about this or edits? Shall we go ahead and take official action on this?
So moved.
So I heard a motion from Eric and a second from Rich. Okay.
All right, let's do a roll call.
Schreiber.
Yes.
Bonachet is not here. Alsaroff.
Yes.
Herman is not here. Iskin.
Yes.
Meeker.
Yes.
Renus.
Yes.
And Savage.
Yes.
Motion carries. And that is staff's last report and business item for this meeting. Well, thank you tremendously from me for the very careful discussion that you were somehow able to do in under 2 hours.
Thanks, everybody. I appreciate it. Thanks, staff in particular.
Yeah,
and the good ideas that flowed out of the committee from everybody else. Thanks, everybody.
Thank you.
Thank you.
Ron,
Happy,
thank
See all
you.
very soon.
yeah, happy Friday and have a safe weekend.
Yep.
Thank you, everybody.
You too. Okay. Bye all.